I appear for kumekucha sheria. I've been reporting in E565/2024 with my learned friend, Mr. John. I haven't seen advocate. It's attached to the and then I also appear for myself. John.
Good afternoon, my lady and my lords. For the third petitioner, my name is Mutembei.
May it please you, my lady and my lords, my name is Nelson Harvey. I appear for the interested party, the Law Society of Kenya, together with my two colleagues, Osea Manwa and Kevin Michuke. Osea Manwa and Kevin Michuke. The man behind the camera.
Maybe perhaps for guidance on which matters we are taking for a month, because this afternoon, and I believe my young friend Mr. Chibi will address it, we were served with a notice from the office of the deputy registrar indicating that there were several matters that were to be mentioned before you this morning, this afternoon, and last evening when we were breaking, we were to come for a ruling. Perhaps we need to have clarity that we do not have a mixture of things.
We are dealing with the ruling, after which the ruling is supposed to be delivered now.
Then
after that, we'll give directions.
Then if that's the case, therefore, then it means there are some advocates who have gotten on record for forum who did not participate or they are not participating in this particular proceedings.
Like who?
Yes, Nelson Harvey.
Lord, lady, we have asked Legal Bureau to spend some little time with this new wife. But it doesn't deplete anything. There's no harm in I appearing on the record.
Is there any other concern before you read the ruling? Our ruling is ready on the consolidated petitions with the lead file being petition number E565. We have set out the structure of the ruling, but we will begin from our analysis of the issues that we think are relevant now. This is the ruling. Having carefully considered the pleadings, submissions, and evidence of record, we consider the following issues arising for examination. One, what are the prevailing constitutional and statutory interpretation methods? Two, whether the Honorable the DCJ can assign judges pursuant to Article 165, sub-Article 4 of the Constitution. Three, other related matters. On the first issue, the Constitution is a document sui generis. It is the norm which legally commands superiority and dominance over any other laws, and its interpretation, as of necessity, must be in a manner that all other laws bow to. The court in S versus Atchison, 1991, captured the centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and the governed. It is a mirror reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. In the matter before the court, the High Court has once again been called upon to address the issue as to whether the Honorable Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and empaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 164 sub-65 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, sub-Article 4, and Article 259, sub-Article 1. Article 20, sub-Article 4 requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the objects of the Bill of Rights. Article 259, sub-Article 1 commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law, human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David Lee and others versus Attorney General, the learned High Court judges dealt with 4 constitutional interpretive principles, being that the Constitution must be interpreted holistically, that the Constitution does not favor formalistic approaches to its interpretation, and it must not be interpreted as one would a mere statute. The Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, and that in interpreting the Constitution, non-legal considerations are important to give its true meaning and values. The Supreme Court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference which I've given